Today, I'm going to talk about one of my favorite UDRP cases, the only case, as far as I know, that involved a single character domain name. Hi, it's Doug Isenberg, and this dispute was over the domain name b.mw. .mw is the ccTLD, or country code top-level domain for Malawi, the country in southeastern Africa. Like about 40 other countries, Malawi has adopted the UDRP, the Uniform Domain Name Dispute Resolution Policy, which means that the same three-part test and the same procedure that applies to .com and other popular TLDs also applies to .mw. As you can imagine, there haven't been too many disputes over .mw domain names. In fact, the one I'm talking about here for b.mw is the only .mw case that has ever been filed at WIPO, the World Intellectual Property Organization. In any event, as you might have already guessed, the complaint was filed by the popular German car company known by the acronym b.mw. The case isn't new. It was decided in 2015. But it's one of my favorite UDRP cases because it raises an unusual but important issue about the role of the top-level domain in a dispute and whether it is a factor under the first part of the UDRP's test, which relates to trademarks and confusing similarity. Specifically, the UDRP requires a complainant to prove that the disputed domain name is identical or confusingly similar to a trademark in which it has rights. Interestingly, the UDRP actually doesn't define domain name, but most panels have said that the top-level domain, the portion to the right of the dot, is ignored for this analysis, meaning that the second-level domain, which a domain name registrant actually registers, is to be compared with the relevant trademark. In fact, the WIPO overview says that the applicable top-level domain, or TLD, in a domain name is viewed as a standard registration requirement and as such is disregarded under the first element confusing similarity test. And that the practice of disregarding the TLD in determining identity or confusing similarity is applied irrespective of the particular TLD. So, applying that reasoning, you can see where this becomes an interesting case. Because if you disregard the top-level domain .mw, then you're simply left with comparing the second-level domain, which is just the single letter B, with the trademark b.mw. In other words, is the letter B identical or confusing similar to b.mw? That seems like a pretty big leap for any trademark owner to make. Now, the b.mw case was fascinating because according to the decision, the registrant of the domain name had engaged in a pattern of registering domain names that reflected well-known third-party marks, including those owned by other car companies, such as Ferrari, Alfa Romeo, Peugeot, Honda, and Porsche. Plus, BMW argued in this UDRP case that the registrant had sought to trade on its goodwill in the BMW trademark by offering to sell the domain name for $1 million. But although these facts might weigh heavily on the third or bad faith factor of the UDRP, they don't directly relate to the first element of confusing similarity. Still, the b.mw decision turned out to be one of those rare exceptions to the general rule that the top-level domain is to be ignored in UDRP cases. So here's how the panel in this case handled the issue. It wrote, "The disputed domain name differs from the complainant's b.mw mark only by the addition of a punctuation mark, a dot, between the B and MW in the mark. While .mw is the TLD, consideration of TLDs may, in appropriate circumstances, be considered when evaluating identity or confusing similarity under the first element of the policy, and the panel finds such consideration to be appropriate in the circumstances of this case." Now, the panel didn't elaborate on what the appropriate circumstances might be to consider when looking at the top-level domain in a UDRP case. But it's easy to imagine that the registrant's actions in this case registering other domain names that included trademarks owned by other car companies, and trying to sell the domain name for $1 million just might have influenced the panel. So, in reaching its conclusion on confusing similarity, the panel didn't compare the second-level domain, the letter B, to the b.mw trademark, and instead it compared the entire domain name, b.mw, to the b.mw trademark. And as you might expect, the panel found that the domain name was in fact confusingly similar to the trademark. And ultimately, after weighing the UDRP's other factors, the panel ordered the domain name transferred to b.mw, which now simply redirects it to its main website at bmw.com. This isn't the only case to consider a top-level domain under the UDRP's first element. In fact, the panel in the b.mw case even cited to a decision involving a .co TLD for the country of Colombia, in which the domain name tes.co was found to be confusingly similar to the trademark Tesco, which apparently is the name of a well-known chain of supermarkets in Europe. So, when should a trademark owner consider the top level in deciding whether to file a UDRP complaint? The b.mw decision doesn't give a lot of guidance, but the case reminds me of that famous quote from Supreme Court Justice Potter Stewart, who said that he might not be able to define obscenity, but he knows it when he sees it. The same might be said for top-level domains. A trademark owner will know if a TLD is relevant when they see it, just like b.mw obviously saw that the TLD .mw was relevant in this case. So as a result, trademark owners should be aware of tricks like this one that cyber squatters sometimes use. And as this decision says, under the appropriate circumstances, the UDRP is a powerful and sometimes even flexible tool to obtain important, high-value domain names. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.